Court calls the case, People versus Kyle Burmeister.
Good morning, Your Honor. James Fifelski appearing on behalf of Mr. Burmeister, who is approaching. Good morning, sir. Please state your name for the judge.
Kyle Burmeister.
Your Honor, this is our first PCC. I am asking for a 30-day adjournment. One of the things I need to gather are medical records that I think will be relevant to our defense or potential resolution, and those often take more than a couple of weeks.
Who's medical?
My clients got signed releases that are going out today.
On an unlawful driving away, and I don't,
Well,
not understanding it.
I think they'll be very relevant to the RO charge and medical history that I think will be important to review with the prosecuting attorney.
Any response from the people?
We have one moment.
Sure. Got all the time in the world.
Your Honor, may we briefly approach?
Didn't have that much time, but yeah, come on.
Yep. Okay. Go! Will you hand me my screen box?
Now go.
Just to advise the court, when I told him that apparently he missed a court day yesterday, it's not a case I represent him on, but he tells me he has never received a notice. He had a notice for today, and that's why he's here. We've communicated about this case, but he was not aware that there was a hearing. So if the court
Well,
can
that's a bit
rein
odd.
him on
That's
that.
a bit odd
Sorry.
because he didn't appear, did a warrant recall, and then didn't appear again.
Nobody anything about
Do you know about another case? Is that a misdemeanor case in this court?
It is.
A misdemeanor case.
nobody told me when I left on Thursday from the jail that this was the only court date that I've had at all.
He was arraigned, I believe, last Thursday on this case. Is that what you're saying?
Yeah.
You're in the jail. They released him with
And they-
paperwork for this case.
Yes.
So I sounds like it's an innocent mistake. He had no notice of the hearing, but certainly he's here to handle whatever legal matters are in front of this court.
Probable cause conference in the matter that were called upon today will be adjourned to March 13th,
I apologize.
2025, 9 a.m. On this other matter, he got a warrant. He recalled the warrant. The date was set. He didn't appear the first time. Now, granted, there was a snow day, but then he did not appear the second day, and notice was sent out. I recall the case from yesterday because he had the previous warrant, and when I issued this warrant, and he just wasn't here.
To the court's knowledge, was he appeared somehow to recall the warrant, or he communicated with the court?
He communicated with the court to recall the warrant, the first warrant.
Okay.
There was a case that got dismissed, and that was one other case that I knew about, and I pled guilty to it.
Tell you what, he's going today. He'll get a date, and then he'll appear, and I'll let the magistrate set the bond on it.
Okay. We
At this point,
appreciate
defendants remanded on the
the
warrant.
soonest available hearing that the court can offer. Thank you, Judge.
Okay, this is 240712, the City of Taylor versus Jason Sullivan.
Good morning, Your Honor. Matthew Zick for the people. Morning, Your Honor. Jeffrey Fanto for Mr. Sullivan. I advised the court that, and the court knows that we had had what we thought was an agreement. Mr. Sullivan has indicated he no longer wishes me to represent him. And that includes any of the attorney group out of his court.
So is he retaining an attorney?
I don't know, Judge. He suggested that he may, but in the interim, I would at least have asked the court to appoint someone out of, or ask regional MIDC to appoint someone to represent him. We also have, the matter was scheduled for tomorrow, but understandably, based on what our agreement was, what we thought it might be, he has an availability problem tomorrow. It's my understanding a complaint in this matter may have one as well. And just ask it be moved to March 21st. And then if he chooses to retain an attorney, then that attorney can discuss the matter with Mr. Zick.
So Mr. Gazicki, there's been a material breakdown of your relationship? Or I'm sorry, Mr. Fanto?
There has been a significant breakdown, yes, Your Honor.
All right, but he's never even met Mr. Gazicki, right?
He's concerned about the association with our group with the court judge.
All right, Mr. Sullivan, what's your problem with Mr. Gazicki, an attorney you've never even met?
Well, with this group alone, I've came to 2 plea deals. Both plea deals have been denied. This has been a waste of almost 8 months of my time, and I've not even been given a discovery package or any evidence of this crime I committed.
So what does Mr. Gazicki have to do with any of that? I've not heard a single word about him.
I have no care for a company that doesn't care to take care of their clients.
Okay, well, Mr. Fanto and Mr. Gazicki aren't even at the same firm. They don't work for the city. They're in 2 separate firms, and they're independent counsel. They're not paid by the court even. They're paid by the Michigan Indigent Defense Council. They're completely independent from the court and the city.
I just made it clear to Mr. Fanto I wanted nothing to do with him or the company he associates with.
All right, well, that's too bad for you, because here's the thing, Mr. Sullivan, you don't get to pick your attorney. If you want to go hire one, get who you want. And if you don't want to work with Mr. Fanto, that's fine. But this idea that an indigent defendant gets to just go through lawyers until he finds the one he wants and to disregard indigent defense counsel because he has some feeling without even having an interaction with that attorney it's insane, sir. And I'm not going to just keep appointing you attorneys because you don't like the outcome or you don't like the advice the attorneys give you. I don't know what to tell you about that.
It's not that I don't like anything. It's the fact that for 8 months now, I've yet to receive my discovery package. I've seen no evidence of this.
Have you asked your attorney for it? Have you had conversations? I mean, what does that have to do with, have you had conversations about that?
So the lawyer's job is to represent me, but it's my job to ask him how to represent me. That's exactly why there's a failure in communication.
If you want a physical copy of your discovery, yeah.
So as a defendant,
did you go to law school?
For the evidence against me? If there's any evidence, that should be at a show cause hearing. I never even got a show cause hearing.
What? Okay, you clearly did not go to law school. It's never been more evident to me, Mr. Sullivan, that you literally have no idea what you're even talking about. Listen, you don't want Mr. Fanto, you can meet with Mr. Gazicki and you can see if you want him to represent you, or you can retain your own lawyer.
That is fine with me. I'm not trying to sit here and argue with you. I know you got better stuff to do.
Well, you are. Mr. Sullivan, if you want to come and get a copy of your discovery or look at it, you can always come to court in person.
I live in Flint. I don't have the option to do that. I've already moved 80 miles away from where this situation happened.
Well,
I'm trying to move on with my life.
You know, when you come for trial, you will have to come in person.
That's perfectly fine as long as I have the time to set that up.
All right, I'll see you March 21st at 8. 1 second. They're resolved. They're resolving them. We'll see you March 21st at 8:30 a.m. for your jury trial.
How am I going to go to trial if I've not seen any evidence and I'm not prepared for trial? This is exactly why I'm firing my lawyer.
Mr. Sullivan, that's not why you're fighting with your lawyer. You're fighting with your lawyer because the plea was revoked. There was a plea offer and it was pulled back, and that's why you're fighting with your lawyer. But if you want to come and speak, you want to speak with someone, you want to get a copy of the discovery, you're entitled to that.
We'll make another copy available, Your Honor.
We've got Mr. Sullivan. Can I give Mr. Gazicki your phone number?
Yes.
All right, I'm gonna do that.
And you can have a copy of the discovery, but I mean, that's either way, you're coming to trial on March 21st, 2025 at 8:30 a.m. We'll see you on your trial date. Mr. Gazicki, you can apprise the court of your status with Mr. Sullivan.
Thank you,
Mr.
Ron.
Zick present.
Thank you, Judge.
Thank you.
Name for the record.
Michelle Young.
Your Honor, as you probably recall, last week we addressed this defendant's phone privileges. After those were revoked, he then continued to call the victim at a different number that we have under her name as well. He called her, I believe, 23 times. There were some under his own PIN, and then after the first day he was in custody, he started using other inmates' PINs to continue to contact the victim in this case. So we have great concerns still that he is still continuing to contact her against court orders.
Your Honor, may we approach?
Yes.
Recording stuff.
All right, record should reflect we had a bench conference in this case. Anything?
Yeah, may I also address, our client has a job interview on the 24th of February and at 11 a.m. And we were wondering if you would able to either give a PR bond or a tether to allow him to go to the job interview.
Well, here's part of the problem with this case, and I'll certainly let the people respond. This case came to my attention for various reasons. There was a hearing, really a hearing, but I heard from the alleged victim in the case. And then upon getting more information, it seems that the parties did not stop contact upon this case and may have even appeared at court together on the date that they were here. Further, the defendant got remanded in part because of phone conversations, then gets remanded this time and still can't follow the court's order. So I'm not going to change his bond. You can certainly after prelim make the argument before Judge Perry, but I'm not changing anything regarding his bond. He'll just remain there, and you know, his phone privileges are revoked, but he's still trying to have contact. So, motion for bond reduction denied. Got to follow the court's orders. Court calls the case of the people versus Barrage Ante Scott. 2 cases.
Morning, Your Honor. Raymond Cook for the people.
Chair for Barrage Scott, Barrage Ante Scott.
Barrage
Hey, Scott, sorry.
Thank you. All right, what are we doing?
Your Honor, Mr. Scott would like to, we're here on 2 cases today, and Mr. Scott would like to waive his preliminary exam in both cases and address bond.
Okay. All right. Is that correct, Mr. Scott? You want to waive your right to a preliminary examination in these cases?
Yes, sir.
All right. Now you understand that that's a proceeding where the people would have to show by probable cause that the offenses alleged were committed and that you committed them.
Yes, sir.
You understand that you'll not have that hearing. You'll proceed to circuit court for further resolution.
Yes, sir.
People also waive their right.
Yes, Your Honor.
Preliminary examination having been waived, defendants bound over to circuit court on a single count in each case.
And as far as bond, if I may address
Well,
that.
why don't we do the waiver? Why don't we?
Oh, yeah.
Arraignment, and then we'll address bond.
Okay, thanks. Sorry, Your Honor.
You waive formal reading of the complaint
Yes, I waive formal reading of the complaint.
and your client standing mute to the charges.
Yes.
And they would waive formal reading, standing mute. Both counts, court will enter a not guilty plea. Pre-trial in this matters will be set for
March 6th at 1:30 before Judge Slay.
March 6, 2025, 1:30 before Judge Slay. As to bond.
As to bond, I believe Mr. Ante Scott is being held right now on case 25FB1013. There is a 5,010% bond on that case. My understanding is that this court gave Mr. Ante Scott a personal recognizance bond, a $5,000 personal recognizance bond yesterday in case 2411706. I do believe that the reasons why a personal recognizance bond would have been justified then count for this case as well. Mr. Scott is not a flight risk. He lives in the community. He is willing to follow any kind of conditions the court sees appropriate in order to be released. He would just like to.
No, he's not.
He would just like to return.
He's going to give, I will say this. Don't look at me like that, Mr. Scott. We've been through this before. He's going to give his best effort He really is. He's going to try his hardest. And then it just happens. Go ahead, Counsel. I didn't mean to interrupt you, but I just had to, because I know Mr. Scott told you that.
Well, on Mr. Scott's behalf, it is just this one case that is holding him, and it does appear he has personal cognizance bonds in all other matters that he has. So I would ask, just because Mr. Scott would like to be able to kind of, family, attend to his health matters, and work out in the community while he is handling these cases. He would request, and I would request.
He got to go see now. Which family member?
My grandma, my granddad.
Okay,
and just my sister and stuff, the people that was helping me out in the past years, that my auntie. And I won't, I'm just gonna do the right thing. Just bear with me one time.
One time?
I mean,
how many times have you been here? Can't even count that high, can we?
No, sir.
No, we can't.
But I will do what you tell me to do. Just please.
Anything else, Counsel?
I would just like to, reiterate that I understand that a matter was before this court yesterday, and it seems like a personal recognizance bond was appropriate at that time.
Only because I knew he was going to be held on this one. But go ahead.
Well, I'd ask the court to consider this bond motion in light of the argument presented.
Response from the people.
Your Honor, I leave it to the court's discretion.
Just tossed it right in my lap. Okay. What was your charge on the case you had before me yesterday?
Just a paraphernalia gave me personal bond, and you told me conditional yesterday, and I thought I was leaving yesterday, but that's
I know.
And Your Honor, I would add that Mr. Ante Scott is willing to go on tether in this court if that is.
We tried that too.
If
the only thing the tether did for us is we saw where you got in trouble.
I won't get in no more trouble.
Sometimes I have no idea what I'm doing. I'm going to grant your motion for a bond reduction. I'm going to give you a PR. Barrage?
Yes, sir.
Understand something.
Yes, sir.
You still have the case before me.
Mm-hmm.
Okay?
Yes, sir.
So if you mess up, you know what I'm going to do.
Yes, sir.
And then I don't want to hear any whining and pleading.
Yes, sir.
Here's the other thing I'm going to do. I'm going to call Judge Slay.
Okay.
And I'm going to let her know what I did.
Okay.
And if you mess up, you're going to have both of us to deal with.
Yes, sir.
And I don't think anybody wants to deal with that.
No, sir.
All right.
So can I ask one question?
Oh, boy.
Mr. Scott, I would advise you.
No, you can go ahead and ask a question.
No,
I may change my mind. Go ahead. What's your question?
No, I was just going to ask you, I can't remember. It's okay.
You couldn't remember?
I can't remember.
It left you, didn't it?
Yeah.
That's probably a good thing.
Okay. That's all I want to say.
That barrage, that's angels just stepping in, stopping you from doing something stupid. All right. Thank you.
Thank you, Your Honor.
He'll be back in a week. What? We're rooting? Okay, we're rooting. Court calls cases of the people versus Forbes Dabney.
Your Honor, I cook for the people.
He's in jail.
Good morning, Your Honor. Hannah Mackey on behalf of Dabney.
Dabney, can you state your name, please?
What's going on here? Hello? Hey,
Hello. Okay.
what's going on?
Tell the judge your name.
Oh,
You
Sam.
recognize that as being Mr. Dabney, because I don't know that we're gonna
Yes, Your Honor.
get an
Hello,
entire.
where am I? Hello, who?
Okay.
All right,
It's
I'm seeing a little better today. And I'm hearing just as well, I guess.
Yeah.
I'm impaired. So this is, who is this I'm with? Hello, can you hear me out there?
Yes, I can hear you, Mr. Dabney. This is Judge Simpson, okay?
Oh, Judge Simpson, okay.
All right. So, Mr. Dabney, here's what I'm going to do. Okay, your attorney has asked for a forensic evaluation. I'm gonna sign that order and give you a new date to come back, okay?
What does that mean? It sounds like
Okay,
you
that
said,
means there are gonna be some folks that are gonna talk to you, and they're just gonna tell us how well you are and whether or not this matter can proceed forward.
what are you trying to say? Am I stuck here in this jail again?
Well, I don't know what's gonna happen with you in that regard, but I'm just telling you what we're doing today, okay?
So I'm not leaving today. Is that what you're trying to tell me?
I'm telling you, you're not leaving today, but what will happen is your attorneys will come down and talk to you about that, okay?
I
So
think that's unusual. The behaviors of the judge should not be had a right to do that. I don't think. Some people are holding me against my will. And
Okay. Okay, well,
it's solved
they may come back to me and then we'll figure out something, okay? On that. So I'm gonna order a competency hearing on a forensic evaluation and
What is that word
competency
you
hearing.
said? I
Hold
can't hear it.
on, hold
I
on,
hear it.
hold
Say
on,
it
Mr.
again.
Dabney. I'm gonna set that for May 22nd, 2025 at 9. Okay, and I'll continue, at this time, I'll continue your bond on that case. Now, I've got a new case.
What is a bond?
Hold on a second.
What's the bond stuff all about?
What's the bond?
Yeah, that's kind of stuff I don't know. Why you guys
Okay,
do
you
that,
can
what
talk to
you're
your
doing.
attorney about it, but right
I-
now, on that case I just did, what do you have it on? I don't have a sheet in front.
Where's my attorney?
Hang on, I'm gonna answer your question. Okay, your bond is set at 10,000 in that case.
Why? I don't believe that
Okay,
that's
well,
right.
here's what you do. You talk to your attorneys about that, and if they want to raise that before me, they can bring a motion to the court, okay?
Well, there's something wrong here.
Okay, so, hold on, Mr.
What is-
Dabney, now we got,
You telling me that you got something against me?
no, I don't have anything against you, Mr. Dabney.
Well, why are you holding me here then?
Well, I'm not gonna change the bond until I get something that tells me I should.
Well, what's this bond crap about? I want to know something about it. And my attorneys are not talking to me.
Okay,
Mr.
I
Dabney,
don't
this is
even know
Ron
I have an
Brown.
attorney. I had
Mr.
looked
Dabney,
for
this is
somebody
Ronald Brown. I
who
came
is
to
my
see you.
attorney.
Ronald Brown, appearing on behalf of Mr. Dabney. I came to see you yesterday for about half an hour, 45 minutes.
Where are you now? I don't see nothing but a piece of paper here. Wait a minute.
You asked for my name and I gave you my name. I can make a bond
Okay.
argument if you like, Your Honor. He's 70 years
Where
old.
is he? I want to see him on the screen here.
I'm at the podium. I'm right here in an
it's not
orange tie.
switching off of me. Can you do a podium view?
Where is he?
Hang on.
I want to see him. I haven't seen him for once. Where, or help me.
Richard,
Who's this?
it's your attorney.
Oh, that's him?
Yeah, you saw me yesterday and I wrote my name down on a piece of paper, Ronald Brown, remember?
Is that you? I see you now, yeah. But you don't.
Yeah, we
look
talked
like the
about
person I
these
saw
things yesterday, correct? And you told me that you have medical conditions, that you have high blood pressure, that you have a heart condition, that you have vision challenges as well as hearing challenges. We talked about these things yesterday. You told me that you were an airplane pilot and that you also that you have a number of patents that you're working on and that you would like to continue working on those patents. You told me about your girlfriend. You told me about you taking tea and herbal medications instead of those medications that were prescribed for you. You told me that you had a heart monitor inserted underneath your chest by St. Joe's Hospital within the last several weeks, that heart monitor is irritating you, and you asked me to implore or urge the judge to allow you to get released so that you can get your proper medical attention through your medical, for your medical needs. We didn't talk about these things yesterday?
Yes, we
Hello?
did. So what you're trying to tell me is now you're going to talk later on?
I'm talking to the judge now to give him reasons to think about releasing you. That's what I'm doing right now. I said I would do it.
Thank you. Then continue on. I think we're getting positive. We're getting.
So you're happy with my performance?
You're doing good, guy. I like you a lot. Yes.
Thank you.
Let's move on. Now, first, one more thing I want to say to the judge. If that's my way I could say something, the way I like to say, that the procedures that are going now against me with all these things is beyond my understanding to be a living soul on the face of the earth subject to the UCC codes of this thing. So I don't like what's going on with this court. And that's why I'm adjusting all these things, because I'm a living soul and a national, and you guys have gone beyond the power of the territory of the people of Michigan. And
Okay.
I don't like
Thank you for that. And Mr. Dabney, I'll think about that, and Mr. Brown will certainly bring all of those issues before the court. Now, Mr. Dabney, there's another case that I have for you that is charging with resisting and obstructing a police officer.
I object to that.
Okay. And
You know,
I haven't.
and there are reasons why that is.
Hold on, Mr. Dabney, hold on. You haven't been arraigned on it, but do you want Mr. Brown to represent you on that, the public defender?
Yeah.
Okay, so
That's
this is
what we
public
need to
defender
do.
case.
Is that what
He's
this
not been arraigned.
process-
You wait formal reading, he stands
Is
mute.
that what
Yes,
this
Your Honor.
process all about right now?
Well, that's part of the process.
Okay, then go on. What else is it?
Okay, well, hold on. Mr. Brown will be down to explain all of that to you.
All right. And I have some other questions I want to ask before you go with
So
him.
let me finish this part, okay?
Go ahead.
So on this case, there's also been a request for a forensic evaluation. I will set this matter for, rather than a PCC, we'll just go to a comp hearing. We'll set that for, what was her name?
March.
Now, who
May
said that?
22nd?
Yes.
May
Who said
22nd. I'm gonna set a date. Hold on. May 22nd, 2025, 9 a.m. All right.
But who said that though?
Who said
Was
what?
it you, Brown? Was it you, Mr. Brown?
The judge sets the dates.
Oh, the judge said that? It wasn't Brown
Yes.
who said that.
The judge said that. He set the date for you, Mr. Dabney.
Okay. So I'm gonna set your bond in this case as just a $1,000 bond, okay? Not the 10,000. Mr. Brown will argue your bond at some point before me, okay?
Something don't sound
come-
right here.
I'll come down to see you and you'll give me additional information so that I can make more arguments why you should get out.
All other standard conditions, including no assaultive behavior or possession of any weapons. I will also no alcohol, recreational marijuana, or any other drug. All right, Mr. Dabney, thank you.
You're not gonna answer my questions, Tim? You're not gonna answer my question.
I answered all of your questions, sir.
Well, what was my answer to my question that I asked you?
What was your question?
Where's my things that has to do with taking this, finishing all these things with monies? Instead of fiat money systems, where's my bond? Not my bond.
Okay.
My minor
So
estate.
what you're gonna have to do,
I want to talk to my
you're
attorney
gonna-
about my minor estate.
this is what I want you to do. Mr. Dabney, I'll hear you and give you an answer to the question. You talk to your attorney, Mr. Brown, and he'll get all of that information to me.
Okay,
And then
then,
I'll make a decision.
as a judge or as a people?
As the judge, yes, that's what I do.
The judge
Okay.
with,
All right. Thank you, sir. We'll be in touch. Court does call the case of the people versus Amy Ruth Boland.
Good morning, Judge. Victoria Burton here, Assistant Prosecutor. People.
Assistant Public Defender Chelsea Vergils with and on behalf of Amy Bullens, who appears via Zoom. Ms. Bullens, unmute and state your name.
Amy Ruth Bullens.
Miss, and let's see, I have before me a plea form that indicates that she'll be pleading. It doesn't say how, but I'm assuming guilty.
Yes, Your Honor. She would like to accept the offer to plead guilty to improper possession of a firearm with the agreement to be sentenced under prosecutor's deferred.
All right. I don't see where there would be an objection to that, but I can't bind the sentencing judge on the matter to that, but all right. So my understanding is she's going to plead to count 2. Is this the maximum penalty of 90, 100? Is that correct?
I believe so.
Ma'am, can you please raise your right hand? Do you solemnly swear or affirm testimony you're about to give will be the truth, the whole truth, and nothing but the truth, so help you God?
Yes, Your Honor.
All right. State your name again for the record, please.
Amy Ruth Bullens.
All right. Ma'am, you can put your hand down. It's this court's understanding that you are going to be pleading guilty to the charge of improper possession of a firearm in a motor vehicle. You understand that?
I do, Your Honor.
That is a misdemeanor punishable by up to 90 days in jail, $100 fine plus court costs, and mandatory forfeiture of the weapon or device. You understand that?
Yes.
All right. And understanding that, you still wish to plead?
Yes, Your Honor.
All right. And to that charge, how do you plead?
Guilty.
All right. Ma'am, I do have to also advise you of one other thing, that while I'm taking your plea, I would not be your sentencing judge, and you would be sentenced before Judge Perry in the 15th District Court. You understand that, ma'am?
Yes, Your Honor.
And you still wish to plead guilty?
Yes, Your Honor.
All right. You understand that by pleading guilty, you will not have a trial of any kind?
That's correct, Your Honor.
All right. Because of that, you'll be giving up certain rights. You're giving up your right to call witnesses to speak for you at trial or to have this court compel their attendance. You're giving up your right to see, hear, and question all witnesses against you at trial. You're also giving up your right to be a witness for yourself or to remain silent, not have that silence used against you. And you're giving up your right to be presumed innocent until proven guilty beyond a reasonable doubt. You understand that, ma'am?
Yes, Your Honor.
You understand you're giving up your right to appeal of right?
Yes, Your Honor.
Are you on probation or parole?
No, Your Honor.
Has anybody promised you anything other than what's been stated here today on the record to get you to plead?
Yes. Tom Eberts told me that there would be off the record. I apologize. That was wrong information. I recant that.
Okay. So let me ask you this, because I just have to make sure the record's clear. Has anybody promised you anything that has not been stated here today to get you to plead to this charge?
No, Your Honor.
All right. Has anybody threatened you or coerced you in any way?
No, Your Honor.
You're doing this voluntarily?
Yes, Your Honor.
And of your own free will?
Yes, Your Honor.
And because you believe that you're guilty of this offense, ma'am?
Yes, Your Honor.
All right. On September 3rd, 2012, the location of 1500 East Medical Drive, City of Ann Arbor, Washtenaw County, State of Michigan. Were you in a motor vehicle?
I had a motor vehicle.
Okay, were you in a car at that point, at some point on that day?
Yes, Your Honor.
Okay. And in that vehicle, did you have a firearm?
I did, to protect myself.
Okay. When you had it in the vehicle, you would agree that you didn't have any lawful authority to carry that vehicle to carry that weapon in that fashion?
I had no idea.
Okay, you had no idea of what, ma'am?
Okay. The reason why I had that firearm is because I just lost my husband in a horrific act.
Sorry, Miss Bullens, you don't have to go into the reason why. Remember we talked about what you could say, you know, what happened, about how you had this and you knew you weren't supposed to. Do you remember we talked about that?
Yes.
Is that true? You had the firearm in your vehicle and you knew that you weren't supposed to?
Yes, Your Honor.
Okay. And just so that we're clear, you didn't have any lawful authority to carry that weapon in that fashion, did you, ma'am?
No, Your Honor.
All right, very good. Counsel, have I complied with the court? Well, would it be proper to accept this defendant's plea?
Defense is satisfied.
You're doing good.
Court will accept the defendant's plea to count 2. The count 1 will be dismissed. The pre-sentence investigation and report is ordered at 15th District Court probation. Sentencing in this matter will be March 14th, 2025. What time? 8:30 before Judge Perry. Bond will continue.
Thank you, Your Honor. Miss Bullens, I'll give you a call.
Thank you, ma'am.
Thank you, Your Honor.
Are you kidding me?
Oh my God.
You have got to be kidding me. What is going on today? This is a joke. Today is absolute joke. We need an interpreter.
I need an interpreter when I cannot express myself sometimes.
Oh my God, sir, put that cigarette out. I don't give a crap that you are outside of this. What is wrong with everybody today? You know what, Miss Green, we're going to start bringing people in person. People going to learn how to act in a courtroom.
Can you hear it? Can you hear it? Ma'am? Ma'am? Can you hear it? Okay.
No patience for that. And trust me, at the end of the day, I'm sitting up here, I'm the one that needs a drink.